Welcome to a Practice Pro CPD, brought to you by LAWPRO.
My name is Sophia. I am Communications Counsel at LAWPRO. I am speaking to you from Toronto, which is the home to many First Nations, including Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. Toronto's also the home of LAWPRO and the Toronto's Lawyer Association. Now, I appreciate that you might not be in Toronto and you might be on traditional territories of other Indigenous people. And we extend our respect and gratitude to all of these First Nations who have lived or are living on these lands and share it with us in peace. Today's program is about practicing in the virtual world. I want you to take a few moments to think about where were you March 12th, 2020? Where were you on March 17th, 2020? And where were you on March 23rd, 2020? Now, I know where I was on March 12th. It was a Friday before a weekend and March break was starting. I was practicing law at an office downtown, but we had remote offices, and I was in our Pickering remote office, and Doug Ford had just announced that we're going to shut down for an additional 2 weeks of school. So March break plus another 2 weeks. And I remember thinking, oh my God, what are we going to do with my kids? And we were going to flatten the curve in 3 weeks. And that sounds really funny now because obviously that wasn't possible. We shut down for much longer. And I would never want to live through a pandemic ever again. And I'm sure a lot of people feel the same way. But the silver lining is the virtual world was born. We started conducting business virtually. We talked to friends and family virtually, and people who have never used Zoom suddenly were using Zoom. And 5 years later, we're still doing things in the virtual world. I love meeting in person because I love to see faces. I like to see expressions, but I appreciate how convenient this is. As I like to dramatically say to my kids, with great power comes great responsibility. And we have learned over time that while practicing law in the virtual world is convenient, there are definitely steep learning curves that come with it. And 5 years later, we are still addressing some of those issues and concerns. So today we're going to hear from Brendan Fagan. He is Chief Underwriter and Director of Underwriting Title Plus, and he's going to talk about virtual ID verification and some of the issues and concerns that have been raised in the last 1.5 years since the rule came into effect. We're going to hear also from John Poyser, who is Senior Litigation Lawyer at Well Partners, and he's going to talk about undue influence and capacity concerns when meeting clients virtually. We're also going to hear from Dina Majelli-Willis. She is a litigator, mediator, managing partner at Willis Business Law. She's going to talk about conducting mediations and examinations for discovery in a virtual setting. And last but not least, we're going to hear from my colleague, Sean Urker, who is legal writer and content manager at LAWPRO. And he's going to talk about best practices to address some of the issues that we still face when we are meeting virtually like this. So without, I know there's some questions already about CPD hours, so that information has been answered by my colleague, Sean Urker. The materials link will be posted in the chat. If you have any questions and answers, please post it in the question and answer box, not in the chat box, but in the question and answer box. We will do our best to answer questions in writing, and we can address some at the end if we have time. So without further delay, I will invite Brendan to get us started with virtual ID verification.
Good morning, everyone. It's a pleasure to be here with you today for the CPD session focused on a critical and increasingly relevant aspect of your legal practice, which is client identification and verification. In today's rapidly evolving digital landscape, ensuring that we know exactly who the clients are is not just a matter of best practice, it's a fundamental requirement, driven both by regulatory obligations, as well as the need to protect your firms from a transaction gone awry. My goal today is to provide you with a comprehensive overview of how IDV technology can assist you in meeting these crucial responsibilities. So over the next 15 or 20 minutes, we'll delve into several key areas. Firstly, I'll briefly go over the general IDV requirements as mandated by the Law Society, as it relates to meeting with your client virtually. Next, I'll get into some of the details of the IDV technology itself, exploring what these products actually do and how they function behind the scenes. I'll then discuss some of the common flags and alerts that the IDV systems can raise and what they mean. And I'll conclude with a brief perspective from the title insurer side of the process. So I'll now start with the Law Society requirements that relate to the fundamental obligations of client identification and verification, and which form the basis upon which the IDV tools operate. As the name states, lawyers must both identify and verify clients, which are two separate steps. Identification is essentially gathering and recording key information about the client, and as you know, includes things like the name, occupation, the address, etc. Verification means using the information you've obtained to confirm that the client is who they say they are. Now, there are 5 options for verifying a client's ID as set out by the Law Society. One of these options is the virtual verification with authentication method, which is the focus here, and is where the IDV technology becomes directly relevant. When meeting with clients virtually, simply viewing an ID over video is insufficient. Instead, the LSO requires that the client be asked to scan and provide their ID. Authentication technologies must then be utilized to verify the document's security features and its genuineness. Additionally, the photo on the document should be compared with the client during the video call, and then the biometric technology would be used for further comparison. This method directly leverages the capabilities of many of the IDV products that are in accordance with the requirements. With that background in mind, I'll now start to discuss the capabilities and functionality of these IDV products. The IDV technology has been designed to verify that a person is who they claim to be. It does this by combining a variety of digital tools and checks that build upon the traditional in-person verification process with the goal of confirming an individual's identity with a high degree of certainty. It works through 2 broad components. The first is the scanning system for ID documents and the individual's face. And the second is the back-end software that performs the verifications. The technology is designed to provide parties with an efficient and secure way to verify their client identities. By leveraging optical character recognition, biometric authentication, and data checks, these technologies have moved the IDV process from a traditional static process into a much more fluid and multi-layered verification check. Now, it's crucial to note that while these IDV products are valuable and sophisticated tools, they are not designed for isolated application, and they should be integrated into the broader context of your work on a specific file. The context of the file is significant, and findings of an IDV report should be considered in relation to any existing concerns or comfort that you have on a specific file. Now, while specific products have their own nuances, the general process for an IDV involves 5 key steps in order to confirm a client's identity. Data capture is the first step, which involves document upload, data extraction, and facial capture. For document upload, the client is typically prompted to upload images of their government-issued ID documents, such as a passport or driver's license. This can be done through a web portal or through a mobile app, depending on the product. The IDV software uses optical character recognition, typically referred to as OCR, to automatically extract the text data from the uploaded documents, such as the name, date of birth, the address, etc. The facial capture is the next step, and it's during this step that the client is asked to take a selfie or possibly a short video of their face And this is the crucial step for the biometric verification. The next step is document authentication. This is the critical stage where the technology verifies the genuineness of the submitted identity document, and it often involves several techniques. The first is the security feature detection, and this is where the software analyzes the document for embedded features such as holograms and watermarks. It compares these features against the database of known security features for various document types from the different jurisdictions. Next is template matching, and this is the layout and design of the document, and how it's compared against official templates, again, to identify inconsistencies or signs of tampering. Machine learning and AI. This is where sophisticated algorithms have been trained to recognize patterns and anomalies that might indicate a fraudulent document. And this can include analyzing the quality of the image, the font used, and the consistency of the document's different elements. The third step is biometric verification, which is essentially the facial recognition part of it. This step compares the client's live face capture, whether it's by selfie or video, with a photograph on their submitted identification document, and it involves several components. The software will identify the key facial landmarks, such as eyes, nose, mouth, in the live image capture and the document. It then extracts unique facial features and creates a biometric template or a face print. A matching algorithm compares the two biometric templates to determine the likelihood that they belong to the same person. This often involves processing a confidence score. And then the last item here is the liveness detection. To prevent the use of static photos or videos, most of the IDV systems incorporate liveness detection techniques. This might involve asking the client to perform certain actions, such as blinking or turning their head. And this is to ensure that they're a real person and present at the time of the verification. The fourth step is the database checks. The extracted information is cross-referenced with various databases to further validate the client's identity and check for potential risks. So the IDV will perform a check against the credit bureaus to access and verify the data that's been extracted from the ID. Many of the products perform a check against the cell phone account, and some of them will have a watch list and sanctions list option, where the client's name and other details might be checked against these lists. The last step is the risk assessment. The risk assessment and reporting, in which the IDV system synthesizes the results and generates a risk assessment. Depending on the product, the report may provide an overall confidence score that might indicate a pass or fail. The report will display flags and alerts highlighting discrepancies, suspicious activity, potential risks. For example, it may say that the document failed the authentication check, and that would trigger a flag, most likely. And the report will also create an audit trail. Those are the 5 general steps that an IDV product will run. And building upon the understanding of the risk assessment, I'd like to delve deeper into some of the specific examples of the verification checks. Regarding the credit bureau check, the name, address, and date of birth from the ID document are cross-referenced with the bureau's records. This check confirms if the bureau information aligns with the ID and verifies a credit file has existed for at least 3 years. Another possible check identifies true fraud warnings in the individual's credit file, which may arise, for instance, if the person has been a victim of fraud or has reported lost or stolen ID. In case your client has a concern about how this may impact their credit bureau, these credit bureau checks are considered soft inquiries, meaning they do not negatively impact the client's credit score. This contrasts with a full credit check where a hard pull would be necessary and does affect the score, which is typically what a lender would perform while making their loan underwriting decision. With respect to the mobile phone account, this check can typically determine if it was a recently activated account, if it's a prepaid account, if the SIM card was changed in the last few hours, if the phone plan is under a family member's name, or if it's a corporate account, and that the cell phone account info sufficiently matches what's on the client's government issued ID. Upon completion of the IDV process, a report is generated summarizing the findings and typically assigns a pass or fail status to different categories. Some reports provide an overall pass or fail result, followed by more specific details about certain identified risks. And they would typically rate this on a scale of low, medium, or high, or at least something equivalent to that type of scale. If a check is deemed high risk, it would typically fail the overall result. Even in the absence, though, of a broad pass or fail score, a high risk warning would clearly warrant some attention. A medium risk can often still lead to a pass, and depending on the other factors, it's something that may or may not require further investigation. In concluding this section, IDV technology automates and enhances the traditional manual process of identity verification by leveraging all of these technologies and ensuring greater accuracy, efficiency, and security. It's therefore becoming an increasingly vital tool for all parties in a real estate transaction to leverage as often as possible. I'd now like to discuss some specific examples of flags that can appear on IDV reports based on actual files that I've come across during underwriting. The first flag to consider is the failure in the biometric verification, where the selfie is compared to the photo ID. This is a relatively common occurrence, and it typically triggers a high risk warning. It could indicate that the individual presented a photograph to the camera or attempted to manipulate the technology somehow. But in most instances, this issue arises from a problem with the photo capture, maybe insufficient lighting, or a bad angle, and it can often be resolved by simply retaking the selfie. Various flags can arise in relation to the mobile phone account as well, and the risk level here can vary significantly. For instance, a recently activated account is generally considered high risk, whereas a prepaid cell phone account is typically flagged on the lower end of the risk scale. While the IDV product provides these assessments, the person reviewing the report should always consider the specifics of the transaction in front of them. So consider, for example, a $1 million private mortgage deal where the borrower activated a cell phone account within the last 3 days. These two factors might initially suggest a higher level of concern. However, if further investigation reveals that the borrower is refinancing an existing private mortgage of the same amount, just because they've, for example, obtained a much better interest rate, there would not be much of a concern with that deal. Conversely, if a borrower uses a prepaid phone flagged as lower risk than a newly activated phone, and the transaction relates to a mortgage with a major bank, that might appear initially to present little concern. However, if it's discovered that the property is mortgage-free and serves as an investment property rented out by the borrower, this transaction then begins to appear quite a bit more risky than the private mortgage scenario. These examples illustrate the importance of applying context when analyzing risk. For both lawyers and title insurers, we don't want to be that new version of Michael Scott from The Office who drove his car into a lake because his GPS told him there was nothing but road ahead. An IDV report might appear satisfactory, but if all other aspects of the transaction raise concerns, those should not be disregarded. We also frequently encounter flags when comparing information on the ID with a credit bureau file. And this could be, for example, a discrepancy in the date of birth, where maybe a couple of numbers were transposed. So you have 1986 on the ID, but 1968 in the bureau. And common sense can typically right, lead to the conclusion that this was just a small mistake. This can happen as well with name mismatches. For example, if someone has changed their name due to a marriage, or if there's an inconsistency right across various forms of ID. As a personal example, that's my wife's situation. Her name is composed of 4 separate names, and on every piece of ID that she has, her name appears differently. And then, as previously mentioned, another type of credit file flag is a fraud warning, and the significance of this can vary. So for instance, if someone placed a fraud warning on their credit bureau and then coincidentally is mortgaging their property, right, that would be fine. But if the fraud warning stemmed from a data breach, that could mean that a fraudster is in the process of impersonating that person and trying to commit fraud against them. With all of that in mind, I'd like to conclude my discussion with a talk about the title insurance perspective on IDV products and their relevance in the underwriting process. We understand that there can sometimes be friction between title insurers and our valued lawyer partners, particularly when an IDV request is made, as this can introduce delays and require additional time from your team and your clients. While we recognize this, I do hope to provide some insight into the rationale behind the titles insurer's approach to this kind of issue. Firstly, it's important to state that title insurers do not take the decision to request the IDV process lightly. While we acknowledge that it may cause inconvenience, it's a measure we implement with much consideration. At all title insurance companies, customer service is a top priority. Our aim is not to impede your transactions or frustrate your closings. Like you, title insurers strive for efficiency and the swift progression of deals. The increased instances of IDV review can impact our operations as well. And that's why we try to keep the use to the transactions that we really deem necessary. However, we have come to recognize that the potential costs of not employing IDV are far greater for all stakeholders. The title insurance industry has seen the mainstream adoption of IDV over the past couple of years. This implementation was not arbitrary and not intended to inconvenience our customers. And as you can probably guess, it was driven by significant financial losses. While title insurers always manage the risk of fraud, the situation escalated considerably starting about a year into the pandemic. Losses reached levels that threatened the sustainability of existing premiums, as well as coverages for certain types of parties. And this would have been the case without some proactive changes being introduced. And it was in this environment that the IDV technology emerged as a necessary tool for the market. During this period of escalating fraud claims, we also observed a broadening in the types of transactions being targeted. Historically, private lender transactions were the primary focus for title insurers, but fraudsters adapted their methods. They became more sophisticated and started demonstrating a lot more patience. And this shift became evident as we began receiving fraud claims involving institutional lenders and claims for standard purchase and transactions. Purchase and sale transactions. While IDV technology is not infallible and is not applicable to every policy order, it has proven to be a very valuable target in mitigating fraud. Title insurers have also refined their underwriting practices, and this has resulted in a substantial reduction of losses. Now, despite these enhanced defenses, fraudsters continue their efforts. The potential gains from mortgage fraud or a series of frauds are quite substantial, and of course, for them, tax-free. For title insurers, this reality just necessitates constant vigilance and the continued use of our fraud prevention measures. While private lenders remain particularly vulnerable to fraud, the increase in attempted fraud across the wider range of transaction types still remains a concern. So consequently, you may, as a lawyer, encounter these IDV requests from title insurers on deals that traditionally might not have raised any type of concern on your end. And this could occur because of the value of the transaction. It could occur because the title insurer possesses some sort of additional info from a prior transaction or from investigations or police reports. And these are sources that may not be available to the lawyer. And it's in these non-private lender transactions that lawyers may observe the slight increase in requests compared to prior years. If this occurs on one of your files, we understand that it may seem unexpected, but please be assured it's not a step that we take lightly, and there's never any intent to catch a lawyer off guard when making this request. Title insurers, though, have learned through this experience that as fraudsters adapt their schemes and leverage their new technologies, we too must adapt to effectively counter these new threats and protect all parties involved in the real estate transactions. So
thank you so
thank you
much.
very much.
Thank you. And Brendan, if we have time at the end, I'm going to invite you back. We have questions, and then maybe there's something else we can address that's a hot topic right now. Thank you.
Thanks so much.
I'm going to invite John. John is going to talk about undue influence and capacity concerns when meeting clients virtually.
So about 10 years ago, I had a client, and he started meeting with me in person. I met with him 2 or 3 times in person. And the reason we were meeting repeatedly in person is because he wanted to change his will. He wanted to exclude family members and include his the person who cleaned his house cleaner. Her name was Flora, and she was a catch as far as he was concerned. She was only like 55 or 60 years old. He was in his 70s. He'd been a bachelor for a long while because he'd lost his wife, and she had high heels and she had blonde hair and she cleaned his house. And he approached me and said that he wanted to change his will. He wanted to install her as the primary beneficiary under his will and exclude his family members. And we met, and it was clear that his capacity was diminishing. I would talk to him about his assets, and he would do an okay job at describing them, but not a great job at describing them. And we met 2 or 3 times at his house. And there was an abrupt change. All of a sudden, he phoned me. And when he phoned me, he was very insistent. He phoned me and said, this process is taking too long. I want her to be my attorney under a power of attorney. I want Flora, the blonde housekeeper, to also be the primary beneficiary under my estate. And I'd like her to receive, can't remember what it was, say 75% of the estate. And I'd like to sign a will immediately. And I thought it odd because he'd been a fairly sort of flexible, friendly guy. He didn't, it wasn't his way to make demands like that, it just wasn't. And all of a sudden he was assertive. I decided I'd visit him again. And on the way home, I stopped at his place. And when I stopped at his place, he invited me in. And we sat down at the kitchen table where we always sat. And on the kitchen table was the phone he had been using to call me. And then taped to the kitchen table was a note. You see it on the screen. It was 1 page. It had bullet points on it. It was highlighted. And it was the stuff he was telling me. Someone had written out an agenda. Someone had written out everything he was supposed to tell me during this telephone call. And he did. And he went back to being his regular self, but the note was just sitting there. I took my camera and I took a photograph of the note because it was clear to me that someone was trying to manipulate him or guide his words or make sure that he would tell me all the important things that I needed to know about his estate plan and that I would get to it and make sure that the housekeeper inherited everything. So therein is one of the primary dangers of a remote interview. When I interview a person, a client, and we're face-to-face. When I interview a client and we're face-to-face, I'm very good at controlling the environment. I make sure that there's nothing on the table. I make sure that there's no one standing over my shoulder giving with cue cards telling me what to say. I make sure there's nothing taped to the table. And all of that gives me the assurance that we're alone in the house, we're alone in my office, we're alone in my boardroom. I can just ask them questions, get answers, gauge what they're trying to do, gauge what they're trying to tell me. It's very easy in the traditional interview to control that environment and make sure that you're getting genuine instruction from a person who's alone and who's not using audiovisual aids or otherwise. And this isn't just about predatory influences. This isn't just about a housekeeper trying to get the estate against a person who's like my client, who wasn't necessarily willing to give it. Bear with me. It's also about capacity. When you assess a person's capacity, and it's a lawyer's obligation to assess capacity in every engagement you go through. When you assess capacity, it's important that the person works from memory. It's important that the client is able to demonstrate the powers of mind necessary to describe their assets, to describe the transaction that they're engaging, to discuss the pros and cons of that transaction, to basically demonstrate an understanding of the nature and effect of the transaction. And you want to do that without an asset list on the table. You want to do that without a diagram on the table. You want to do that in circumstances where it's clear that they are proceeding from memory. And again, you have to control the environment to be able to get into that. And I suppose another critical element is the ability to gauge nuance. And I'm old school, and we're all doing repeated over and over again Zoom calls and Teams meetings and all that sort of business. But there just is no substitute for sitting across from someone and looking at them and gauging their demeanor, gauging the way they act, gauging what they do, gauging whether they're looking you square in the eyes or not. It really is it feels like a more powerful tool to determine whether a person is engaging in a meaningful way with you, and to come to your own conclusions about whether they understand things and your own conclusions about whether they're being forced to do things. The other reason why an in-person interview is so powerful and a remote interview is less so is in an in-person interview, you can control fairly clearly for communication problems. I'll do a thing frequently in an in-person meeting where I say to the person, I want to make sure that you can hear me clearly, and I'm going to count, I'm going to say it, I'm going to give you a sentence, and I want you to repeat it to me. And then I cover my mouth and I say, the rain in Spain falls mainly on the plains. And then I see if they can respond by repeating the sentence. Sometimes they can't. And I realize I'm dealing with someone who's lip reading. Face to face, you can deal with people who have difficult hearing. If they can't hear you, you can put a pocket talker on them, a headphone device with a speaker on the table that you can turn up and down to make sure that they can absolutely and clearly hear you. They'll give you the thumbs up and their eyes light up when they can actually hear the person talking to them very clearly. You can control for hearing and communication problems in the room. It's really hard to do it when you're miles apart doing it by video. During a will planning engagement or something like that, I will often, while I'm taking instructions, make a diagram of my own, which shows how the wealth is going to be distributed at death. In the case of this client, I would have shown a little stick man for him, and I would have shown his lifeline ending, and I put an RIP. I draw a box and say, this is your estate, and I put his house and his investments and his cottage and all that sort of business in the house. And then I show an arrow saying 75% housekeeper, 25% family, and I put the dollar amounts beside each, 3 million, 1 million. And that helps me understand exactly what the client wants to do. I might write down executor, Flora. But at some stage, if it's in person, I can turn that around and I can put the diagram in front of them temporarily and discuss it. And that kind of ability to use diagrams to enhance understanding, to make sure that they're on the same page, is very valuable and something which is only possible when you're dealing with in person. You can share screens, you can do all that sort of business. But trust me, when you've got clients with diminishing capacity, when you've got clients who are potentially being unduly influenced, it's really hard to do that technological stuff. It's really hard to share a screen in real time and have them demonstrate that understanding. They have difficulty with technology. I have difficulty with technology. And I also find that older clients are just basically fearful of technology. They don't have a laptop, or if they do have a laptop, they're barely able to turn it on. They don't have an iPad, or same thing, they have trouble turning it on. If you ask them to take a selfie of themselves, they look at you quizzically. They understand what a selfie is, but no one asks them to take selfies of themselves. They don't take selfies of themselves. It's just not a go. So a lot of the technology which might be used in a remote interview to try to bring some immediacy to it, to share diagrams, to verify identification, is lost when you're dealing with someone who's in their 80s or 90s, who is suffering from diminished capacity and may not, even if they were still capable, have kept up with modern technology. Another thing which I find concerning is that, I mean, there are predatory people out there, and if you try to rob a bank, there's guards, there's police a moment away when they push the red button. There are doors that lock. People get caught and they go to jail for a long while. But if you just try to take advantage of the guy whose house you're cleaning, if you just try to take advantage of an uncle, no one goes to jail. There's millions of dollars to be secured. And I'm encountering lots of predatory activity in and around my estate planning practice. I do estate litigation, I do estate planning. But the example I've given you, the diagram you're looking at on the screen, it's not out of the pale. Every year I get 2 or 3 instances where I have real concerns that someone's being manipulated. And what we see on the screen, I believe, was an effort by that caregiver, by that house cleaner, to manipulate. And because she couldn't come into the office because I wouldn't let her sit in an interview, she had no way of doing it unless she could conspire to get this done remotely. As soon as it was being done remotely, she was in control. She had the chance to influence the process. For all I know, during the call, when he phoned me with this piece of paper on the table, with his cheat notes on the table, she was standing behind him. For all I know, she was pointing to things on the chart for him to say, pointing to point number 1, pointing to point number 2, nodding her head. They could have practiced it. So the whole environment, the whole remote environment lends itself to predatory behavior. And the in-person environment, the in-person environment is very strong in being able to control for that. When I meet with someone in person, I make sure that they're alone. I make sure that there's no one standing at the door. I make sure that there's no one standing outside the door and in the next room who might be able to hear. I look at my client and say, you can say anything to me. It will never get out of this room. You lose that ability in significant measure when you're dealing with a remote environment. But sometimes we have to do that. I mean, what I've done in large measure is just given you a cautionary tale so far about how important it is to conduct your interviews in person. So be it. That's true. But the fact of the matter is that we are going to be conducting some of our meetings remotely, and we are going to have to assess capacity remotely, and we're going to have to deal with the prospect or specter of undue influence remotely. It's just going to happen. Now, what I've been doing when that happens is, particularly if the client is older and perhaps in a personal care home, the 80-year-old or 90-year-old is not using a computer. Even the client I've been describing, the gentleman who tried to give everything to his housekeeper. If I'm dealing with one of those individuals and I have to do it remotely, I need someone who can help them. I need a helper. And one of the strategies I adopt, not the only strategy, but I think it's a fairly strong strategy, is I try to adopt a younger person who's technologically adroit, who does not stand to take any advantage from the transaction. And then I'll carefully identify them, I'll carefully verify their identity. I carefully make sure that they're not an imposter or a predator pretending to be someone else. I can do all sorts of things with them. I can verify their identification using the kinds of technology which has been described during the first session. I can make sure that I've got myself a helper who can be in the room with my client, who is not going to be impeached or is not going to be the predator themselves. As soon as I get there, I've got a lot stronger position. They can set up a laptop in front of my client. They can set up the Zoom call or the Teams meeting. They can test the technology. They can put a pocket talker on my client's head so my client can hear. I can satisfy myself with them in the room that my client is engaging and listening and hearing. And then I can make sure that there's nothing on the table. I can say, make sure there's nothing on the table. We can't have a family tree on the table. We can't have an asset list on the table. We sure as heck can't have a list of points that the client is supposed to tell me that was given to them by someone else. So the helper can do all of those things. If the internet starts to break up, if the client can no longer hear me, the helper can say stop. The internet's breaking up. We're going to have to try to reestablish this internet connection in order to continue this meeting. If someone walks into the room, the helper can say someone's just walked into the room. I can tell the helper, walk around the house and tell me that no other person, no family member, no house cleaner is lurking anywhere in this house. I need to know it's just you and my client. in that house, and they can come back and tell me that it's so. Another thing I'd recommend beyond the helper strategy, and again, I've found that helper strategy to be very powerful in dealing with someone with diminishing capacity, who's older or what have you. Another thing that I think is very helpful is don't try to do this all in one throw. In other words, schedule 2 or 3 video conferences over 2 or 3 days, each with the helper. And the first one, just test the technology and make sure it's all working, and get the client to interface with you, to interact with you, to answer questions on screen. The client gets more comfortable. You get more comfortable. There are bugs. You work out the bugs. The next day, you might do another interview. You might continue to talk about the prospective transaction with the client, with the assistance of a helper. And you'll discover the client is still more comfortable. And so are you. And everyone's getting to be comfortable with the technology, and it's working. And bugs are being worked out. And then maybe on the third day is when you have the real interview. The third day is where you have the functional interview, where you're trying to assess capacity. On that third day, you will ask all the questions necessary to assess capacity. You will ask all the questions necessary to probe for undue influence. And on that third day, you have every prospect of success if you've practiced a little bit. And again, you have to test on the day of the actual hearing to make sure that all the technology is working. And you have to make sure that that the client is really interacting with you in a meaningful way without any cheating, without any notes and that sort of business. There are some actual advantages potentially to a virtual meeting. When you are assessing for capacity, you should be creating a record of how the client performed. The key is not your conclusion at the end of the day that the client had the capacity to engage in the transaction. The key is not your conclusion at the end of the day that they were proceeding of their own volition and free from undue influence. Those are important, and you have to draw those conclusions for the transaction to move forward. But the key is to create a record of evidence which, if the transaction were later challenged, can be brought to court or can be brought to the family in a settlement scenario, and allow people to develop a level of comfort or discomfort as to the capacity level and voluntariness of the client in that transaction. Creating that record is a big part of the job. Creating that record is very important. One of the things that can be done if you're dealing with Teams or if you're dealing with Zoom, you can actually record the whole interaction. The whole interaction. You could record that third meeting, or you could record all 3 meetings with the client's permission. Making very sure that the client understands that you're creating an audio-visual record which will be stored in the file for future use. It can be done so long as you have that permission. And what you end up with is a very nice, clean record of say an hour-long or 2-hour-long video conference with a failing client who answers all sorts of questions about their assets and all sorts of questions about their family tree and all sorts of questions about everything that may be relevant to the transaction. And then talks about the transaction, answers questions about the transactions. Yeah, I want to do it, the client might say. The family has been, that never visits me, and they don't need the money. And my housekeeper always visits me, and she's nice, and I want to give her the money. All of that gets laid down into recorded format. All of that's available to the lawyer if the lawyer later concludes that the transaction can proceed because there appears to be capacity and the absence of undue influence appears to be present. So there's an advantage, a real advantage in some instances, to be able doing this on videos because it's so easy to create a recording. Another advantage is just expediency. It's all well and good to say that you're going to go through 3 interviews. It's all well and good to say that you're going to make a trip out to the bedroom community where the individual lives, but that might take a couple of 3 weeks to get through. There are going to be some instances where the person's health is precarious. There are going to be some instances where it's important to act now and to get your instructions now and to generate documents now. And in those instances, sometimes the ability to perform a virtual meeting is golden. They might live far away. They might live 2 hours away, but you might want to get the job done now if they've got surgery tomorrow. So no one is saying that virtual meetings are a bad thing in this context, but where capacity is at issue and undue influence are at issue, it's important that you try to meet in person. And if you have to do this remotely, you try to get past the risks. Try to find a meaningful way to put yourself in the same position as you would have been face to face. The final thing I'll say is just some individuals in the audience might be thinking, I don't assess capacity. That's not my job to assess capacity. If I'm really worried, I'll hire a doctor to assess capacity. But the fact of the matter is that it is a solicitor's obligation, a lawyer's obligation in every transaction to take the steps necessary to satisfy themselves that the client has the necessary mental capacity, necessary powers of mind to proceed forward with a transaction. It's your job. And that job that's been confirmed by the Law Society in England, it's been confirmed by the Law Society in the United States. In Ontario, there's been a recent practice direction saying that lawyers have an obligation to assess capacity. It's your job. So you've got to ask these questions, and you just got to create the environment where you can get meaningful answers. And of course, if there's doubt, hire a medically trained assessor. Hire someone who can go through the process with you on an expert basis. Let that psychiatrist or other clinically trained assessor meet with the client, or in person or remotely. If they're going to do it remotely, you might want to be part of the process so that you can guarantee there's a genuine meeting of the mind and the technology is working. Your job. Anyways, my time is up. I'm going to call it, I'm going to stop sharing. And thank you very much. It's an interesting topic. I've been delighted to discuss it.
Thank you, John. Thank you. Dina, if you can talk to us about dispute resolution and examinations for discovery in a virtual setting, please.
Yes, thank you for that introduction. Just getting my presentation up. Okay, so we all know that when the pandemic hit, there was rapid technology change that was forced on the justice system. And with that, lawyers and mediators began offering remote services, and that included mediations and discoveries. And at the outset of the pandemic, there was concern that virtual services would be not as effective as in-person services. And some of these concerns resulted in a few cases that I want to discuss with you today before I jump into the crux of my presentation. The first case was Arconti versus Smith. And this happened early on in the pandemic, May of 2020. And it was a case conference, and it resulted out of an objection by plaintiffs to a video conference examination. And Justice Myers in that case ordered that the examination be conducted remotely in order to keep that litigation process moving and avoid delay. The parties were encouraged to embrace technology, and it was this decision that set the tone as to what parties were to expect regarding the use of technology in litigation during the pandemic. Now, fast forward to September of 2021, we had the decision of Warsaw versus MTCC, and that was a dispute between plaintiff and defense counsel. Plaintiff's counsel wanted to conduct the discovery of the defendant in person, and the two could not agree, and so a case conference was convened. And the court considered what was the newly amended Rule 1.08 sub 6 factors. And again, it was Justice Myers commenting that virtual proceedings promote efficiency, affordability, and enhance access to justice, and ordered that the discovery occur virtually because there was no good reason for it to proceed in person. The court rejected the idea that an examination for discovery should be conducted in person because that was the preference of counsel, or because it's the way things had always been done. The court also said that the party that was insisting on a method of examination or a mode of examination should have a really good reason for it. And so those were the cases from early on in the pandemic. And then in April of 2022, the court implemented the guidelines to determine the mode of proceeding in civil cases. And in those guidelines, it said that mediations and examinations for discovery were to be held in person unless the parties consented to it being conducted virtually, or unless the court specified a different mode of proceeding.
Dina,
Yes?
sorry to interrupt you. You're still on the cover slide. Not sure if you wanted to move
Yeah,
up.
no, I'm good.
You're good? Okay, sorry.
Yeah. But in reality, virtual mediations and discoveries outlived COVID. And despite the Superior Court of Justice's guidelines of in-person presumption. And then what happened is by February of 2024, After receiving much input from all justice participants, the Superior Court of Justice amended their guidelines, and they no longer provided that discoveries and mediations be presumptively in person. And when parties cannot agree, they convene a case conference, and the matter is determined according to Rule 1.08 sub 8 and the factors listed in 1.08 sub 6. So all that to say that despite the pandemic being over, there are still many compelling benefits to out-of-court proceedings being conducted virtually. These benefits need to be weighed against the potential drawbacks in deciding the mode of proceedings in any given case, and that's out-of-court proceedings, specifically discoveries and mediations. So now I'm going to get into the crux of my presentation, where we outline the benefits and challenges of virtual mediations and discoveries. And I'll lay out some best practices for you to consider and apply in your respective practices. So what are the challenges? These are not in any particular order, but the first is technology challenges. So oftentimes technology can glitch or connections can be dropped. Second, you've got the issue of Zoom fatigue or disengagement, which can really impact outcomes in a mediation. Third, you have the difficulty when dealing with people virtually of building trust and rapport. Fourth, the difficulty identifying power imbalances because you're not in the same room with the decision maker to determine, are they being sent texts? Are they being sent emails by someone who is maybe having some influence on their decision making? Number 5, some can say that they're less settlement focused because the magnitude of the mediation is lost on parties when you're conducting these by Zoom or Teams. There could be less learning opportunities for junior lawyers, let's say. And some can also argue that there's access to justice challenges for those that don't have access to computers or technology or reliable internet or the internet at all. So now let's talk about what the pros or the benefits of conducting mediations virtually. And again, in no particular order, we're looking at significant cost effectiveness. So you have the elimination of costs associated with gas, venue rentals, catering, parking, copying, binding, delivering mediation briefs, etc. We're also seeing time efficiencies. So you're eliminating the need for travel, and you're more effectively using any type of downtime during the course of the mediation. Number 3, they're more flexible and convenient. And because of that, you're minimizing any cancellations or delays that may occur, let's say, if all of a sudden your child is sick or one of the parties' children is sick. You also have technological efficiencies, including things like screen sharing, virtual breakout rooms, which both can offer much effectiveness and sometimes can save a mediation that's going sideways because of emotion. The mediator can often put somebody into a break-off room and prevent the settlement from being derailed. You've also got some mitigation against power imbalances. Sometimes it works to your advantage in that it reduces any anxiety associated with having to face the other party face to face in a particular room. And you can also say it does, in some respects, enhance access to justice, because virtual mediations allow practitioners to serve more clients, including clients in remote or hard to serve areas. You have an increase, it increases the availability and quality of services. And so now you can hire mediators that are more specialized or more experienced, let's say, in areas that are not local to you, or you can engage an expert who might want to give a presentation at your mediation that otherwise would not get in a car and drive the 4 hours necessary to speak for 20 minutes. And lastly, you could also argue that it facilitates settlement. Clients are less stressful when they're not in boardrooms and in a lawyer's office, and sometimes that can leave them more prone to settlement. So what best practices should you consider when conducting or preparing for a virtual mediation? Well, first, decide what is best for your client and their case. Think about client preferences. Are they tech savvy? And is it the best course to conduct a virtual mediation? Think also about, does a client have access to technology? Do they have disability issues? Do they have caregiver responsibilities? So think about all of that when deciding whether or not you should conduct a virtual mediation. Second, identify any cultural or linguistic needs. So do you need an interpreter, for instance, and is that better done in person? Third, does a case involve the participation of a self-represented litigant? And does that self-represented litigant have access to technology? And can they address issues in writing? And so that's really an important consideration. 4, you want to replicate the gravity of an in-person mediation. And this goes to enhancing the ability for settlement opportunity. And so you want to ensure that the parties are participating from a private, quiet space, that they're dressed appropriately, and that they're abstaining from activities like eating or texting. Also, don't rely on Wi-Fi. It can be spotty, cause lags, and often can freeze on you. And it derails the entire virtual mediations at times. 6, do a test run. Ensure your client has the technology and knows how to use it. And 7, engage all participants by using eye contact and by addressing them personally to mitigate against disengagement and to establish rapport. And so, of course, there may be others, but for the sake of time, we're going to move on to virtual discoveries and the challenges that are faced or that you will face when conducting a virtual discovery. Now, many of the challenges that I listed for virtual mediations apply here, so I'm not going to repeat them, but I've only identified those that are particular to examinations for discovery that are held virtually. So number 1, the potential for coaching of the witness. Number 2, they're often difficult to assess credibility when you're not observing the demeanor and body language of the witness in person. They can be more difficult to keep the flow of questioning when doing these virtually. And virtual discoveries can depersonalize the proceedings. And of course, the use of an interpreter can be more challenging because it disrupts the pace of questioning and can often lead to people speaking over one another. What are the pros? Other than the pros we've identified for virtual mediations, which apply here likewise. Those particular to virtual discoveries include they facilitate disclosure, because if a document was missed during the disclosure process, sometimes parties can pull them up right on the screen and share them. And so they can cause or help with unnecessary undertakings. And number 2, virtual discoveries provide for more accurate transcript. And that's because the reporter has the ability to record the session and review it when preparing the transcript later on. So what best practices should you consider when preparing for a virtual discovery or when deciding to conduct a virtual discovery? And number 1 is do a test run and be prepared. Make sure the client or the witness understands the nuances of a virtual discovery, including waiting for counsel to finish their question before answering and providing a moment before answering to allow for their lawyer to object or refuse a question. Number 2, Counsel, clients, and witnesses need to agree that the examination will not be recorded by the participants. And likewise, put it on the record. Put it on the record that the witness is alone, that the witness is not going to reference any documents or notes unless directed to, and that no participant will be recording the examination for discovery except for the recorder, or the reporter, I should say. Number 4, how do you prevent coaching? Well, you have to be vigilant to make sure that the witness is alone in the room, and sometimes you may even need to ask them to pan the room with their camera. And you need to make sure that the witness will not be referring to any aides to assist in answering any of your questions. Number 5, use and utilize your technology functions. So that includes screen sharing if you are referring to a relevant document. But when you do this, make sure you maintain a view of the individual that is being examined. You also want to look at your camera rather than your screen so that you're establishing some eye contact with the witness. This will often result in better and more direct answers. Also, when you are using your screen share function, be careful that you don't have any notes or privileged documentation on your screen because otherwise you share those as well. And lastly, on the utilizing your technology, make sure you mute or turn off your camera when you're not the one posing questions and another counsel is. It minimizes background noise and it minimizes confusion for the witness and the reporter regarding who's speaking. Address people when you speak to them. We often use eye contact and body language when we communicate, but this is not easily discernible when you're using a webcam. So address who you're speaking to, whether that be counsel, the reporter, or the witness, to avoid confusion. And you want to organize all your electronic documents. Ensure they're tabbed and numbered for easy navigation. And so with that, just some closing remarks. We've proven in the last few years that mediations and examinations for discovery virtually can be done successfully, but you need to be vigilant because misconduct can occur, and it has happened. There is some case law, 2 decisions in particular, Kaushal versus Vasudeva. It was a case in January of 2021, and it was a motion to strike the respondent's affidavit because it was found that the respondents, when giving his answers, had the wife and son in the room coaching him. And so the court said, you can't do this, you can't interfere with the fact-finding process, and struck the respondent's affidavit. And lastly, Demakis versus Demakis. Again, it was a 2021 decision. Here, counsel spoke to his client during a break in his virtual cross-examination. And so the other counsel brought a motion to either stay the action or strike the proceedings. And the court determined that, yes, this did occur, and yes, it was improper, but there was no harm, and so they were not prepared to order anything further. So I guess the main takeaway is this: you need to balance the concerns with fairness, efficiency, protection of the vulnerable, and the promotion of justice in deciding whether to proceed virtually for any out-of-court proceedings. So do this with caution and on a case-by-case basis. Thank you.
Thank you, Dina. Next, we're going to hear from Sean, and Sean's going to talk about best practices in a virtual setting to address some of the concerns that we see regularly.
Thank you, Sophia. I'm just going to share my screen as well. And there we go. Thanks everyone for joining us today. My name is Sean Erker, and I'm the legal writer and content manager at LAWPRO. And I'm going to be talking about best practices for video conferencing, some basic advice, but some of this will hopefully be a little new to people and maybe some new tips that you can use when engaging in your own video conferencing. I'm going to talk at first about why video conferencing skills are important for lawyers to use. And then I'm going to be talking about the kind of technology and tools that we can use to improve our setup. Then I'm going to give you some tips for organizing your virtual meetings, some of which you may do already and some of which you may be able to incorporate into your workflow. And then I'm going to talk a bit about the psychology of virtual meetings and why sometimes they are less effective than in-person meetings and what we can do about that. And then finally, I'm going to give a little bit of a discussion about confidentiality and security when incorporating video conferencing. So why are video conferencing skills so important? Well, to some extent, it is a matter of signaling. It's the same reason why we might put on business attire before we meet with a client. We want to present ourselves as someone who is confident, who is capable, and who they can trust to handle their legal affairs in a skillful and professional manner. And so the way we present ourselves, if it is in a video conference setting, can impact the way we are seen. And from LawPro's perspective, actually, we see a lot of claims that can be rooted in either a breakdown in the relationship between the lawyer and the client or in communication problems. So miscommunication between the lawyer and the client. And both of those things can be impacted by how you present yourself in a video conference and how you handle a video conference. It also allows you to set the proper tone for a meeting. One thing that we sometimes talk about is what to do about our backgrounds. Do we do a blurred background? Do we put a logo up? Do we create a space in our office that has a particular look? I'm using my personal bookshelf behind me right now, which does have some personal items, and that can give a more humanizing element to the conversation. Perhaps a few items such as family photos or some Maple Leafs sports paraphernalia might also do the same trick, but you also want to make sure you're presenting a professional tone. At the same time, if you were doing something like examinations for discovery, you may want to completely eliminate any personal items in order to maintain a veneer of professionalism in the same way that a court has a very strict veneer that doesn't particularly allow for the same kind of personal items. And so these decisions and being conscious about it can help in that regard. It also allows you to create an environment where you are communicating with the client and you both are on the same page and you both understand what is being asked and what is being said. And video conferencing, if not handled correctly, can impair your ability to do that. So I'm going to start off with some tools and some techniques. Now, the important thing to remember, of course, is that we're lawyers and we are not professional videographers. There's only so much we can do, but there are some very simple steps that we can take to greatly improve the appearance of what we do in a video conference. So, for example, we can choose where our light is coming from. Now, this is Naomi Dummett. She is the communications director at LawPro, and she has helpfully volunteered to be my goofus in this goofus and gallant scenario to show what not to do. Now, Naomi has a very nice office, and she has a large window, and her computer faces the window. Now, it might be quite nice to show off your window, but that presents a large light source behind you when you are engaging in a video conference, and that can create a lot of problems. For example, if you are backlit, your camera may automatically try to set the exposure to the bright window behind you rather than your own face. That will cause you to be cast in shadow. Even worse, sometimes the camera may keep trying to decide what level of exposure it actually should be trying to do. These are the automatic decisions that a webcam or a laptop camera will be making at all times. And so sometimes it can go back and forth. As you move and perhaps you let a little more light onto the screen, suddenly you'll dip in and out of shadow, which can be very distracting. So you want to avoid having a light source directly behind you. You also want to avoid having the light source directly beside you because that can throw a whole lot of light on one side of your face and put the other side of your face in shadow. Again, it can be extremely distracting and it looks unprofessional. In most circumstances, you want to avoid having a window entirely. You probably want to close it and use some controlled lighting when doing video conferencing. If you do have a window open, make sure it is in front of you so it is casting light flat onto your face. Now, this next example that I have here is from me closing the window. I don't have additional light though, so the only main light source now is the overhead light source for this room. Now, one of the problems with that is that it decreases the amount of light going into the camera, which increases the noise as the camera tries to automatically brighten the image so that I'm easier to see. So you can see that this is a bit more blurry, a bit more distortion. As well, you can see that there's a mix of color temperatures. This might be getting a little bit complicated, but I assure you it's a simple takeaway. An overhead light source that is an incandescent light or is an LED that is set to what is often known as warm lighting. It comes across as yellow lighting. It's the kind of lighting you might have in a bedroom or a lamp. And that has a different color to it than the light that comes, for example, from a monitor. If you have a white document open on your monitor, that is white light that is coming directly onto your face. So in this scenario, I have an overhead light that is quite warm, and I have a monitor light that is quite cool. It's a much whiter, brighter light coming directly onto my face. And the problem is that the camera doesn't know how to white balance. The camera doesn't know what color my skin should actually be. It's a little confused because there's two different colors of light sources. And so you can see in this image that my face is actually quite washed out. I look very pale, perhaps a little sickly. That might not be the appearance or the impression that I want to get across. And so the way to avoid that is to have consistent color temperatures. If you're using LED lighting, you can usually change to have a cool light or a warm light. Now, the important thing is that whether or not you're using cool light or warm light, you want them to match. So in this picture, as you can see right here, I am using consistent color temperatures. And at this point now, the light is now no longer making me look particularly pale because the camera knows that all of the light is coming from a consistent color temperature. As well, in this light, I am using a ring light, and I will explain that in 1 second, but that is putting light directly onto my face in a flat way, which prevents there from being any kind of unnecessary shadows, and it gives me a very clear and professional setting. So ring lights are a great thing to incorporate into your workflow. They can usually be placed directly behind the camera, behind your computer, behind the laptop. They're quite small, so they usually don't take up too much desk space when you're not using them. They are extremely affordable. They cost $25 to $100. And if you're just using this for basic video conferencing, you can usually rely on the low end of that spectrum to purchase something. This gives you very clear light and makes sure that you always have access to something that will properly illuminate you and won't cast distracting shadows. At the same time, you might want to consider purchasing a specific USB microphone. Now, USB microphone is the important term there because when you are purchasing professional microphones for uses in podcasts or recording, oftentimes these microphones use what's called an XLR cable to send a mic line into a mixer, which then would go into the computer. That's too complicated. That's not what we want to deal with. What we want to deal with is something that is easy, kind of a plug and play scenario. And so what you want is a USB microphone that uses a USB cord to go directly into your computer. The benefits of that is not only do you get higher quality audio, but these kinds of microphones usually have cardioid polar patterns, which is just a fancy way of saying that it only picks up directly what is in front of it. So what you are speaking goes into the microphone, and outside noises, such as what's happening in the next room or what's happening outside, are often not incorporated and often not heard. And as well, you avoid the echo effect of being in a room and having a whole bunch of sound vibrations bouncing off walls and back into the microphone. This increases the clarity of everything that you're going to be speaking to. And again, these things can be quite simple to place at the back of your desk when you're not using them, and they're relatively affordable. This example right here is what's called a Blue Yeti. It is a USB microphone, and the higher end of that runs for $150, and the lower end, which I believe is called a Blue Snowball, is usually about half that, $75. Now, you also want to make sure that you're using headphones. Now, headphones, of course, can protect the privacy and confidentiality of your conversation. It also prevents unwanted echo or feedback. Now, one of the things to keep in mind is that your program, whether it is Zoom or something else, will often have automatic noise cancellation within the software that will try to cut out and remove unwanted background noises. Now, the issue with that is that, like any kind of AI or any kind of modern computer program, it is highly imperfect. And so it may also cut out your own voice some of the time. It may become distracted and confused about what noises it's supposed to remove and what noises it wants to keep. And that's another reason why having a microphone that has a cardioid direct pattern will help avoid having the software try to decide what noise it wants to keep and what noise it does not want to keep. One other thing to keep in mind is that Bluetooth headphones can sometimes interfere with the microphone, any kind of microphone that you are using, because that kind of Wi-Fi interference can be quite disruptive. You also want to make sure you're mounting your camera at eye level so that you are looking straight into the person and there's direct eye contact in that regard. Now, another thing to keep in mind is you don't want to be too close to the camera. People that are leaning in can have their face appear quite large, which can trigger a subconscious fight or flight response. So you want to make sure you're a ways back from the camera so that it is a more natural kind of conversational distance and it feels more appropriate for people. You also want to take a moment to familiarize yourself with your video conferencing software. Now, this is Zoom because we are using Zoom, but one example I like to talk about is actually just happened to me a few weeks ago. I attended a meeting. The other person set up the meeting, but they accidentally set the audio of the meeting to telephone rather than computer or telephone and computer. And when they did that, it actually prevented anybody from being able to use their computer microphone or their computer audio. The whole meeting had to eventually be shut down and a new invitation had to be sent, which took about 25 minutes. It kind of, everyone got a little bit frustrated. It's a very understandable mistake, but it's one reason why you should take the time to go through the settings in your computer program to understand what you're doing. When you look at the software, you can also double check. If you're using something called a USB microphone, you'll want to make sure your audio is set to that USB microphone and not set to your built-in microphone. Now, I have about 4 tips to give you about preparing for your meeting. The first is don't assume that your clients know how to use your software. It can be an extremely good idea and helpful to prepare a how-to guide to send to clients or anyone else you're going to be meeting with virtually that just lays out exactly the steps that you want them to take to set up their computer on their end. This avoids having to explain it every single time. And even if it seems rudimentary, you can't always assume that the person that you're talking to has even done any of this before. So these kinds of how-to guides can be very helpful. Second, check your bandwidth before you have your meeting. These kinds of things can be done very quickly and easily on Google. Just you type into Google Internet Speed Check and you will be able to find out what your speed is and whether you have the bandwidth to have the meeting in your current location. Recommended download speeds are about 20 megabits per second and upload is about 5. Most scenarios, you will have plenty of bandwidth, but if you are at all concerned about that, it's always good to double check. Another good thing to do is to provide some backup contact info. This will ensure that if someone does drop off or they can't get their system working, that they'll be able to call you and nobody's waiting on one end, wondering where the other person is, double checking their email to see if an email was sent, those kinds of things. So to send a cell phone number before the meeting to say, if you have problems, call me here and we'll figure it out. And then tip 4, set and explain the agenda at the beginning. And this is going to lead into the final thing I want to talk about here for the next 2 minutes before my time is up. And that is just about the psychology of these conversations. So the rhythm of online conversation is different than the rhythm of a conversation in person. Now, we become accustomed to the same kind of beats and timing that we have when we talk to people. Transition time between speakers in an in-person conversation averages usually about 200 milliseconds. And in that time, the listener has to simultaneously comprehend what the speaker is saying, plan the response, and predict when to cut in. Now, we do all of this subconsciously, and we've all gotten very good at it in our lifetimes, and we don't even realize that we're doing it. But unfortunately, Zoom and video conferencing impairs our ability to do this. A study done for the Journal of Experimental Psychology found that the transition time in Zoom was actually about 500 milliseconds, which was far more than the 30 to 70 millisecond addition that the internet speed time would have added, just the time it takes to get from one side of the world to the other through the internet. And what they found was that this increased time was based on the fact that people didn't know when to cut in. They had a hard time taking their cues from the next person. They had a hard time starting the next part of the conversation. And this can be a problem because participants often attribute delay in the back and forth to confusion. And they often feel like the other person isn't listening to them or the other person isn't understanding what they're saying. This can be a big problem when the client needs to have trust in you and needs to have confidence that you do understand what they're saying and you can help them with their legal problems. So here are just a few quick tips to deal with that. First, I would recommend speaking with a steady cadence. And this also ties into the beginning when I said set an agenda. At the beginning of the meeting, tell the other person, if you organize the meeting or if it's your client, that you will be explaining everything to them and you will also give them time for questions. They don't need to feel like they need to interrupt you. And then put a question to them and say, do you have any questions of what we're saying so far? And do this every 5 minutes. Don't wait for them to try to interrupt you because that can be very frustrating on their end and it can break down the timing of the conversation. It can be a little awkward at first to keep putting it to them and say, hey, do you have any questions? But trust me, it gets a lot easier. And I see you, Sophia. I'm just going to be one more second here. Also, another good suggestion is let them know in advance if you are going to be taking notes or referring to another screen. People understand that, and when you're in person, it's very understandable to see a person write something down on a notepad in front of them. It feels like they are actually listening to you, that they're concentrating, but in a video conference setting, when someone is looking down or when they're looking off screen, it always feels like they're not listening to you, even if you are specifically doing something for them. So just let them know in advance that you are going to be looking at your screen to the side at certain points so it doesn't make them feel uncomfortable. Now, I'm going to leave it back to Sophia. Thank you very much for this time. Hopefully, maybe we can go a little bit over because I know we do have some questions and we've taken a lot of time here, but thank you again for listening to me today.
Thank you, Sean. That picture of you with the close-up, I moved back, so that's a really good reminder. Thank you. We had a jam-packed session. I want to invite Brendan back to talk about something we didn't plan to discuss, but it is a hot topic, and we have 1,200 attendees, and that's my kitty, one of the downsides of being at home. And so, Brendan, if you want to join us, and if you can just maybe share a few words, as of October 1st, 2025, we know that title insurers in Canada will be subject to money laundering, anti-terrorist financing, including requirements to report to FinTrack. You can just share a few words on that, and I know we can't cover everything.
Yes, yeah, for sure, Sophia, thanks. So in the fall of 2023, the federal government informed the title insurers that we would become subject to the Proceeds of Crime, Money Laundering, and Terrorist Financing Act. Right now, there are many other participants involved in a real estate transaction cycle who are already subject to this legislation. The applicable regulations for title insurers were published in July 2024. But as Sophia mentioned, they're not yet in force. That's happening October 1st of this year. Since we were informed of that, approaching a couple of years ago, the 4 title insurers have been in regular discussions with representatives from both FinTrack and the Department of Finance to better understand our forthcoming obligations. In those discussions, we've actively and consistently advocated for a practical, proportionate approach to compliance, particularly with respect to the information that we would be required to obtain from lawyers during the title insurance ordering process. Initially, the government proposed that title insurers collect a significant amount of client info from lawyers, which would have posed a substantial burden on our lawyer customers. But I think more importantly, their initial requests appear to raise a similar constitutional issue that the Supreme Court ruled on in the 2015 decision that involved the Federation of Law Societies. We firmly push back on those expectations, and the requirements that are scheduled to come into force are significantly more limited than originally planned. So as it stands right now, at least effective October 1st of this year, title insurers will be required to establish an anti-money laundering compliance program, fulfill certain identity verification and record keeping requirements, and submit suspicious transaction reports when required. We anticipate that a compliance guidance document from FinTrack will be released shortly and will provide a lot more clarity on some of the outstanding issues and questions we have. But based on what we know so far, we expect to be able to meet our obligations primarily by collecting some additional ID and transaction-related info through the title insurance order forms, which we believe would not add much of a burden to the current process for obtaining a policy. With that said, there will be more information from the government in the coming weeks, we hope, and the coming months, and we will definitely be conveying this to you as it becomes available to us.
Thank you, Brendan.
Thank you.
So we are almost at time, and we are, I think, at time. I want to thank everybody for attending today. Thank you to the Toronto Law Association. Thank you for those at LAWPRO behind the scenes. There's a few things in the chat. There's a survey. If you can please complete that, that will give the Toronto Law Association and us at LAWPRO an understanding of what you want to hear about in the future from us. There's also information on a program that the TLA is offering, so if you could take a look at that. Today's CPD is eligible for 1.5 professionalism hours and risk management credit that will go towards your 2026 premium. And the materials will be posted on the Practice Pro website along with a recording of this program. You should probably see it in the next week or two. Thank you, everyone.